Now, this 51 ground is actually a summary of everything that the appeal court said, because in their first paragraph of the petition, as we saw yesterday, they said that they are appealing against everything that the appeal court said, meaning there is not even a single one they said they are going to withdraw from. So, and all of them are summarized in 51 points. So let me give you, because it's about 70 something pages. There is no way we are going to exhaust them here. Even as we go along in this discussion, we're going to be interplaying it with that of the PDP, because of course you know that there are areas where their prayers were the same. And then there are a few areas where the prayers of PDP and Labour Party differed. For instance, the 460,000 forfeiture in US was a prayer made specifically by Labour Party. The issue of education qualification and certificate was a prayer made by PDP. So when it comes to that qualification before the election, as at the day of election, there are a few areas where PDP decided to concentrate in one area and the Labour Party concentrated on not the other area. But even when it comes to the non-substantial compliance to the Electoral Act, even though PDP and Labour Party complained about it, there were also the Labour Party went in a more detailed manner to point out where those non-compliance occurred and how it denied them their right by either that their votes were not completely counted or their votes were shifted to APC. All right. But PDP based their own generally on non-compliance, specifically about collation and co. So it's important that we understand where they differed and where they intersected. And we're going to be discussing it going forward, because the day the judgment is going to come, it's going to come together, I believe, just like the judgment of the appeal court. So that being said, the main thing Labour Party did, which I liked in their appeal, is this: everywhere where the appeal court judges countered their prayers, trashed it, or did not, of course, as we know, grant their prayer, what Labour Party did, which is also what PDP did, was that they went there, they told the Supreme Court judges, this is exactly what these judges said. They copied what the appeal court judges said, and then they went to either the Electoral Act or the regulation or the manual of election or the Constitution. They went there, they lifted, they said, this is what the law said, which we abided by. But the judges did not comply with it. Therefore, they erred in law. For instance, let me just give us one example. Is it okay for you to just give me one of the slides? I don't want to do us lecture today, but let me just give an example so that we understand what I'm trying to say. Maybe give me the clip of the slide of the Labour Party, the one Labour Party slide that we have. Okay, this one is PDP, but it's still okay. All right. Now, okay, this is Labour Party here. Fine. Now, if you look at this thing here, it says this is the one on top is what the court said. The one below is how they countered it. And if you permit me, I will just maybe run through it so that you appreciate how this case is handled. Because this time around, it's no longer Labour Party versus APC or Tinubu or INEC. Yes, they are still in the first page, but what it is literally everything Labour Party said here was the judges erred in law. The judges erred in law. For instance, this is ground number 4. Remember, there are 51 grounds. Ground number 4, they said here. So they pick each ground being what the judges said, and then they show what the law said. They said here in this ground number 4, it says the court below, that's the way in the legal language, how you refer to the court you are appealing their judgment, which is now in the appeal court. The court below erred in law when he held that it is a misconceived argument. This is what the judge said, to state that the decision of the apex court, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decision of the apex court in Belgore versus Ahmed on the mandatory requirement for stating material fact as provided in paragraph 4 of the same first schedule of the Electoral Act. A look at the environment in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular plea unit or specific places where alleged irregularity and malpractices have occurred. Now, what the judges said here is that they are referring to judgments of Electoral Act as far back as 2003, 2007, and co, where in those days, after they have finished, mutilating the result, overinflating the figures, they now say you must prove it by going to do what? Show us the polling unit, show us the village, show us the street, show us the number of the polls that is standing, all those kind of things. Now, that is what the judges were still going back to. And look at how Labour Party countered them here. Labour Party says particulars of error. They have four points they raised to counter what the judges said. It says the presidential election of 2023 is regulated by Electoral Act 2022. Period. Any other reference to any other Electoral Act, according to the way we say it when we are in primary school, is babash. It does not hold water. Because the Electoral Act 2022 is superior to the one of 2011, 2010. It's superior to it. In fact, it is the error in the one of 2010 that the 2022 corrected. So for a judge to be making reference to the conditions of 2010 when the condition has been defined in 2022 is, like I said yesterday, FIFA setting a new rule, like goal technology. Now they are using electronics to determine. These days, when they play and there is a confusion, the referee will say, hold on. They will go and use the electronics to watch when the ball dropped and how it dropped. Is it not true? But you know that some 8 years ago or thereabout, the moment referee does P, it's final. But now it is no longer final. So for somebody to come into football today and say that the moment referee blows is over, the person does not understand the new rule. And that is the kind of thing the judges did. And that is what the Labour Party is pointing out to them, saying, no, the judges, you erred in law. Now look at the second point. It says, the court below overlooked, listening is important, the court below overlooked the fact that further particulars are not mandatory under the Electoral Act 2022 to arrive at the justice of the petition. In the other Electoral Act, those kind of particulars the judges are saying you must produce are no longer mandatory. in the Electoral Act 2022. Number C, it says the court below failed to take into account that the appellant had tendered exhibits indicating the polling units and the wards where there were widespread irregularities and malpractices, but the same were not reckoned with by the court. Nigerians, did you hear it? They are saying here that even the places where they believe they had issue, they tendered the exhibit, but the court decided not to touch it. So how can you say blame them? Now, number D says the court below resorted to undue technicalities in its consideration and determination of the petition. Undue. It's like they are trying to tell the judges, these men, they just woke up. It's like they were saying, what is it I am going to say to knock off this thing? As I've often said here, the judges were interested in delivering judgment. They were not interested in delivering justice. Now, the implication, as I said in our program, in our live session in the afternoon today, is this. The implication is this. Will the Supreme Court judges align themselves with the appeal court, or will they align themselves with the Electoral Act 2022? Now, let me connect it with what happened in Kano State. Can you show me that slide of the Kano State again, please, if you don't mind? As you can see here, this is the lowest court, the high court that tried state tribunals. Now, I am not to stay here to say whether the judges in this case were right or wrong. But Nigerians, you bear us witness that after 2 weeks ago, when the appeal court delivered their judgment in the issue of this presidential election petition, that many of the things they spoke against, the lower court in the tribunal took the other side. For instance, Peter Obi and even Atiku, in one of their ground, where the appeal court said that the issue of Shetima and co is a pre-election matter, that it should have been ventilated before the election. Majority of the reason why some people, according to the tribunals in the lowest cadre, which is High Court, majority of the people, they have already asked INEC to issue a new certificate of return, where supposed pre-election matter that the other parties brought, like I think in Sokoto State, the PDP in Sokoto State challenged the fact that the governor, the person, I think is in Sokoto State, the person who came in as a governor did not finish, does not have secondary school certificate. And the court removed him on that ground. But these are the kind of things that they're saying is a pre-election matter. And then even though this appeal court said it's a pre-election matter, remember that PDP went to court against APC in the matter concerning the way Shetima was nominated. And the lower court said they do not have a local standard, that it is internal party issue, which is a pre-election matter. You remember that? They went to appeal court. The same appeal court held on to the judgment of the lower court. They went to the Supreme Court. The Supreme Court held on to it. This same appeal court that said that as a different political party, You cannot challenge what happens in party primaries and in nominations. You can only challenge it if it will be a disadvantage to you. Because before the election, it was a disadvantage to party members. But after the election, it becomes a disadvantage to another party. How do I mean? Because if both of us were to be in different political parties, and the standard is that everybody must appear by 10 a.m., and you appeared by 10:05 a.m. because your political party delayed you, you are now taking advantage of me because we are supposed to be here by 10 and you came by 10:05. If the judges allows you, it means that they have made me spend more time than you. And that is the ground I have to challenge your qualification. And we know times without number that even this same appeal court, they held on to many cases where another party challenged the other party's candidates in the way on the issue of nomination, on the issue of certificate, and on the issue of forgery. So what I don't know is this. Okay, not even what I don't know. What I do know now is this. The appeal court is final. We can see that the high court, their judgment is different from what appeal court gave. So let us see now which one the Supreme Court will side. Because whichever one they side becomes precedent. It becomes a rewriting of our law going forward. Now, let me show our audience one of the other smaller slide from the PDP that we touched in the afternoon. There's something important there that I would like to use to relate to what I want to say while we start rounding up. The one of the PDP, no, the smaller one, so that we don't the one on the page, the smaller one. Good. That is the ground 3 of PDP. They still said that the judges erred in error. Now, they said here, this place, look at what PDP did. As you can read, the PDP specifically quoted the sections of the Electoral Act, the sections of the regulation, and they put it in order. Section 1 here, you can there are particulars of error here. They put that in section 60, subsection 5 of the Electoral Act, that it is mandatory. The judges said it's no longer mandatory for INEC to upload, that INEC can choose anything they feel like. But the law say that INEC can choose whichever way they like, and that way they like in the transmission, they will put it in their regulation. If you go to INEC regulation, they specified in the INEC regulation that it is a must. So you see PDP, they listed all those sections of the law. So the question we need to ask ourselves is, will the Supreme Court judges throw away these black and white sections of our law? Or will they throw away what the appeal court said? They have done it before. They have thrown away what the appeal court said before. But will they do it this time around? Or will they be more interested in pleasing one person than serving Nigeria? Okay. Before we delve into the other aspect of what happened in the US and how it also gets interwoven in all these things, because some people were asking that question in the comment section, let me pause and say, you have any question to ask, please, if you don't mind?
Yeah, Doc, no. For now, no. Just continue with what you are saying.
Okay. Now, we all have heard it. It's trending in the news all over. Atiku secured a judgment yesterday in the US. The question people are asking is, what is the implication of that to this appeal on the Supreme Court? Does it have any bearing? The answer is yes. The answer is yes in two parts. Number one, Enahoro Eba, as we have said here times without number, had gotten that particular document. And that document now, the court also gave Atiku even further right to interview the staff of Chicago State University under oath, which means everybody in the US in that university will either wake up to lose their job or say the truth, because they will be interviewed under oath. They will be questioned under oath. Now, Atiku is telling the court, the Supreme Court, as one of his grounds, that the exhibits, the material exhibits that was brought to the court by Enahoro Eba, which has been confirmed. Now, listen to how the way it goes now, which has now been confirmed by what the court gave him, is the same thing. And that the appeal court rejected to look at it because he did not front load it. Whereas by law, he's not supposed to front load it because Enahoro Eba came by subpoena. Are you watching it now? And APC and their lawyers and Tinubu's lawyers had appeared in the Presidential Elections Petitions Court with what they call the academic record of their candidate. Now, this has given Atiku the authority and the power to challenge that what they submitted is wrong if it is not what he has. And if it is what he has is different from what was submitted to INEC. And if what was submitted to INEC is not exactly what the school gave, then it is forged. And if it is forged, nobody with a forged certificate presented to INEC is qualified. Now, remember, let me tell you what Atiku asked. One of the questions Atiku asked is that the Chicago State University must give him the specimen of the certificate design that was issued to graduating students of 1979. And it also includes the principal officers that signed the certificate of graduate in 1979, so that he can compare it with the officer that signed the certificate that was submitted to INEC. Now, you and I know, my fellow Nigerians, that the person who signed the certificate that was submitted to INEC joined the university 20 years after the certificate was issued. Are you watching it now? That is as it has to do with the law. I have already told us earlier on in the afternoon that assuming self the Supreme Court threw out everything, that Atiku has succeeded in bringing to the end. He has exhumed this case that has been in the pipeline since 20 years ago, 2003, and the truth will appear. So that if the president of Nigeria has been honest all this while, we will know that people like Atiku were just busybody people. And many Nigerians were just criticizing a man who is minding his own business. But if what Atiku is thinking is, and what many Nigerians are thinking is anything to go by, it means that for more than 20 years, a lie which have been sustained for more than 20 years, Nigerians will finally come to terms with the one that is the truth. So that is a win too. And number three, that judge has exonerated the American judiciary by making sure that he gave that judgment despite all the pressure that came from Nigeria, from APC, from even the university. So it's a win for all of us. And I must say thanks to P2B, a man who came out with the mantra of go and verify. Everybody now is in the business of verifying. Look at the kind of thing that is popping up in the internet. Now, I don't know how true that may be, but you do know that Ambode, during the 2019 campaign, did say something about the current Lagos state governor, that he has issue in America. And now we are talking about the former Speaker of House of Representatives, who has been debarred in America. All these people are coming from Lagos State. And all these people are APC. And all these things are being opened up these days. It's not because the internet is here now. It's because somebody empowered us with that ability to go and verify. And everybody is working hard, digging, verifying, publishing, exposing. So that's a win for Nigeria. That's a win. Okay, that is it.
Yeah, thank you very much for breaking it down for our viewers to understand what is going on. So guys, yes, this is what we have for you guys tonight, just to let you understand what Peter Obi is saying in his appeal, and also what is contained in Atiku's appeal. We are happy that Atiku was able to submit his, and Peter Obi's team of lawyers were able to submit theirs too. So we are really happy that they succeeded in that appeal. We just look forward to hearing what the the Supreme Court is going to rule. Hopefully, they will stand with the Nigerian people and not with our politicians. But we know the problem we have today in Nigeria is leadership problem. We have problem when it comes to leadership, and that is what we want to fix. That is what the 2023 presidential election was meant to fix, if not for what INEC did. But we are hoping that justice will be served, because looking at what is happening in the country today, we don't really think APC can manage the affairs of Nigeria properly. Look at how a bureaucracy, or how do they even call it, they think the rate at which they are proving to own the government is really increasing. People do things without fear because they feel their own person is now in power. We don't want all this kind of thing to continue in Nigeria. We want to have a country we all can believe in, a country we all can be proud of. That's just what we want. So at this point, we are just begging God to intervene so that the Supreme Court will stand with the Nigerian people. And like we've always said, that the Minister for Justice was once the lead counsel for the APC. Now he is the one that foresees the affairs of the judiciary. So possibly he will be the one to select the judges who are going to preside over these appeal from Peter Obi and from Atiku too. So you know what that means. So it will take an extraordinary decision for a judge to come out to say, I'm not going to compromise my stand, even if it means losing my job, if it means losing my gratuity or my pension or whatever. I'm ready to do that. Let me stand for the truth and defend the truth, so that the Nigerians will remember that I did this, I paid this price for the cause of this country. So we just look forward to seeing such things happening in Nigeria. Unlike what happened, at the tribunal level, we saw the judgment. Peter Obi's lawyers are now referencing to what our judges at the tribunal ruled. You find out that it appears as if they didn't even check the Electoral Act, neither did they even look at the Constitution before making some of the rulings that they ruled, that it was not mandatory, for results to be transmitted electronically. And Peter Obi's lawyers are now proving them wrong. Come and see it where it is stated categorically that it is a must that results must be transmitted electronically. And INEC chairman came out to tell Nigerians that that is what they are going to do during the election, but they failed. So we look forward to getting justice and nothing outside justice. So guys, at this point, we want to say a very big thank you for being a part of this live session. Please do us a favor, give this video a like, and also subscribe to our channel. That would be a big way to support us. Don't forget to turn on the notification bell for future uploads. Please, I have the link to my Twitter account, that's X, on the comment section. Please do me a favor to follow us there, because we'll also be giving some updates there. Please, I would really appreciate it if you do. And with this, I want to say a very big thank you for joining us tonight. Doc, thank you for all your contributions.
Thank you.
God bless you.
Please, just before you hang up, I want to ask us, please, I am particularly going to read all your comments based on this session. So because the volume of things, both from the Labour Party and the PDP, they are voluminous. So if there is a specific things you want to ask questions about, go ahead so that we can handle it and be precise when we come back in session again. All right. Have a wonderful night, everybody. Good night. Thank you.
Good night. Bye.
Yeah. Bye.